The foundations of patent protection. What is a patent? A patent is an intellectual property right granted by the government of a nation to an inventor that gives him or her the exclusive right to an invention for up to 20 years in exchange for disclosing the details of the new technology for society's benefit. In the United States, a patent is a legal instrument in the form of a document issued by the U.S. Patent and Trademark Office, or USPTO. This legal instrument gives the inventor of any new, useful, and non-obvious machine, process, manufacture, or composition of matter the right to exclude others from making, using, offering for sale, or selling the invention throughout the U.S. or importing the invention into the United States. A patent is granted for a limited time in exchange for public disclosure of the invention, and a U.S. patent is only recognized domestically and cannot be enforced in another country. The legal foundation for U.S. intellectual property rights was actually laid by the founders in 1787 in the very first article of the U.S. Constitution, which outlined the precepts of our democratic society. In Article 1, Section 8, Clause 8 of the Constitution, Congress was given the authority to promote the progress of science and useful arts by securing for limited times to authors and inventors the exclusive right to their respective writings and discoveries. So, what is the rationale for issuing a patent? Every society that affirms intellectual property rights offers two basic justifications for doing so. First, the bargain or contract theory, and second, the natural rights theory. The bargain theory starts with the common sense premise that people will be encouraged to invent new products and services that benefit society if they are likely to profit by doing so. The U.S. Constitution thus offers inventors a bargain. If you invent something useful, then the Constitution and statutes say that, as a quid pro quo, you can have the exclusive right to that invention for a limited time, after which it goes into the public domain and belongs to society. Many patents were issued as a result of this bargain, like the invention of the cotton gin in 1794, which boosted agricultural production 100-fold. Or like the invention of the semiconductor in 1957, which created a $1 trillion new industry and millions of jobs. There is something so simple yet economically potent about this concept. As Abraham Lincoln, America's only presidential patentee, noted, the beauty of the patent system is that it added the fuel of interest to the fire of genius. The second common justification, the natural rights theory, invokes another common sense premise that most of us instinctively hold to be true. That the product of mental labor is by all rights the property of its creator, no less than the product of physical labor is the property of its creator. As Daniel Webster put it, a patent does not give an inventor a right to his invention or an author a right to his composition. Rather, it recognizes an original, pre-existing, inherent right of property in such invention or composition. This right is not absolute, of course, and inventors' inherent rights may at times be restricted by national security or other concerns. Then, for disclosing to the public the details of this invention, to which the inventor has this inherent right, for society's benefit, the government will enforce the inventor's exclusive property right to that invention for a limited time. Two important public policy goals are thus served. First, the inherent property rights of inventors and authors to their creations are protected, thereby helping to ensure that the wellsprings of creation and productivity do not dry up for lack of incentive. And second, the benefits derived from these inventions and creations are ultimately harnessed to the public good through disclosure, thus promoting the progress of the nation and the general welfare of its citizens. So, can patent rights stimulate invention and sharing? To help understand how patent rights can stimulate invention and promote technological knowledge sharing, economic historians Naomi Lamoreaux and the late Kenneth Sokoloff offered the following thought experiment. Imagine a world in which there was no patent system to guarantee inventors property rights to their discoveries. In such a world, inventors would have every incentive to be secretive and to guard jealously their discoveries from competitors, because those discoveries could, of course, be copied with impunity. By contrast, in a world where property rights in invention were protected, the situation would be very different. Inventors would now feel free to promote their discoveries as widely as possible so as to maximize returns, either from commercializing their ideas themselves or from licensing rights to the idea to others. The protections offered by the patent system would thus be an important stimulus to the exchange of technological information in and of themselves. Moreover, the cross-fertilization that resulted from these information flows would be a potent stimulus to technological change. And sure enough, extensive research in the U.S. and other nations shows that patents do in fact serve a powerful stimulant to technological change and knowledge sharing.